Carmen Chatterjee. I think he told me she's supposed to be there on Monday, so there's something going on. Yeah, they got it on the 20, just a couple of days. All right, so that's all right. Yeah, it was pretty extensive, the stuff they had on the review.
Yeah, I read it.
Probably most except for like just looking at the plot plan. I've never seen a plot plan like that.
Yeah, it's a big drop down.
Yeah, it's a tough plot.
Yeah.
Okay, thank you, I appreciate it.
Generators. Basically, I'm just doing offset. Because a lot of people will do it. That's it. Yes, if that. So, I'm just evaluation, but it turns out that it's cool. You see what I mean? But let them know. Hey, will they put them on? There was one guy that time around, but he was but other than that,
Not yet.
What are the cases am I supposed to get? Hey. Hey, Renee, we going in this order?
that's what I'm saying. I'm working on it.
If they are here.
Okay, are we ready? Danny, are we ready to start? Okay. Good evening. My name is Kristen Ike. I'm the Code Enforcement Special Magistrate for the City of Deltona, and I'm calling the Special Magistrate hearing of October 23rd, 2024 to order. First thing on the agenda is roll call, so I will have all of the code compliance officers introduce themselves.
Mark Gibson, Code Compliance Supervisor.
Danny Ron, Code Compliance Manager.
Sharon Shivers, Fire Marshal.
Sam Schaller, Assistant Fire Marshal.
Lisa Nadeau, Fire Inspector. Jessica Cotterman, Hearing Clerk.
Renee Kearney, Code Compliance Supervisor.
Greg Scott, Code Compliance Officer. Barry Sparling, Code Compliance Officer.
Dennis Glasser, Code Compliance Officer.
Nicholas Lopez, Code Compliance Officer. Bashir Jersey, Code Compliance Officer.
Thank you. If you'll please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to run this evening, and I'm going to read this so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight, and any witnesses each of you call, will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the city code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order that the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first place. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by sending a written notice of appeal to the circuit court within 30 days of the execution of my order pursuant to Florida statutes, section 162.11. The procedure of the hearings today will be governed by Chapter 162 Florida statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify. Tell me what you think I need to know about your case. Present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number, and the city will proceed first. The city has the burden of proving that the code violation exists. Then you will be allowed to respond. For each case, I intend to admit the case file and the PowerPoint presentation that is shown by the city, and you should have received a copy of your case file when you came in this evening. If you did not, please let me know when you come up. And I, again, intend to admit those documents unless a specific objection is received. I will take the cases in the order that you signed in, first come, first served. And I do have some cases that have been withdrawn or continued. So let me go ahead and announce those. The withdrawn cases are DEL 24-083B, 631 Cloudcroft Drive, DEL 24-097, 1048 Pioneer Drive, DEL 24-099, 28410 Earlshire Court, DEL 24-100A and D, 514 Giralda Avenue, and Fire 24-0057, 609 Bell Tower Drive, Unit D. If you are here for any of those cases, you do not need to stay, as well as the following cases continued, which is DEL 24-081, 1510 Howland Boulevard. So if you're here for any of those cases I just read off, you do not need to stay. I will go ahead and swear in everyone who intends to testify today as a group, which includes the code compliance officers. So if you intend to speak to me tonight, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do. All right, thank you. All right, I will go ahead and get started. Okay, first case is DEL 24-100, A, B, C, and D.
Good evening. My name is Bashir Turkzi. I'm employed by the City of Deltona as a code compliance officer. This will be cases number DEL 24-100B, DEL 24-100C.
Okay, so
They're both the same violation.
A and D were
withdrawn.
Withdrawn.
Correct. B and C will be for B and C would be for the same violation, no permit. So I'm just going to
okay.
read the violation once. This This case will be the City of Deltona versus David Montalvo. The property address is 514 Giralda Avenue, Deltona, Florida 32725. Parcel ID number is 81-300-5240-180. This property has been brought before the special magistrate for more than one violation. These violations are as follows. This is violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for wall alterations, and this will be for case B, and for C will be to obtain a permit for the exterior door. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida 32725. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office with the permit number when obtained. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that were taken. These two violations were first identified in April 26th of 2022, and two cases were created to address them. However, the cases were closed by mistake while the property was still in violation. After finding out about the issue, a notice of violation was issued on October 2nd, 2024, giving the property owner until October 11th to come into compliance. I've also spoken to the property owner, advising him of the need to obtain a permit for the work done on his property. Unfortunately, as of today, the property is still in violation. The city would like to request 30 days for the property to come into compliance, or a fine of $50 per day per violation to be imposed until such time that the property owner notifies the city of compliance.
Okay. And so has a permit been applied for, or hasn't even been received?
Not at this time, no.
Okay.
Not yet.
For either B or C?
Correct.
Okay. Sir, will you state your name and address for the record?
David Montalvo, 514 Giralda Avenue,
Okay.
Deltona, Florida.
What would you like to tell me about the case?
Well, like he said, the first time they mentioned it, I was never addressed regarding to take care of the door that I opened on the side of the garage. And all this happened since COVID-19, so I had to do some arrangement because we were getting outside hose down and clean. I put it in the front of my door. I put a sink to wash my hands, and we were getting inside, dressed outside. So I tried to make a bathroom inside the location, inside the garage.
Inside the garage?
Yes, and then I did the side. I opened a door just to be safe to enter on the other side, and I opened also a opening for the window. And I put an AC there just to have more air into it. It was not my intention to do anything on wrongdoing. And at this moment, I came here to get orientation regarding permits. And it looks like they misunderstood me and I was misled. So what they told me, and I came with this paperwork, to the office. They told me to just draw something like this, and to obtain a vent that I bought and put there, and get a an architect to come in and see it. So I'm getting just quotes right now with architect working on it. And I also got picture proving that I follow instruction what they told me when I came here regarding the event and installing a fire extinguisher. The fire is a monoxide, I think it is monoxide. Monoxide, I don't know what you call this right now, but it's monoxide. Yeah, thermal monoxide, that. So I did that. I came back again, and that's when they told me that this was supposed to be done by a licensed architect, not by me. So, but I've been contacting these people, and they got a long schedule. They've been scheduling from 45 to 60 to 90 days to address my petition of going home and taking measurements and doing what they have to do to get the things corrected. So that's why I would like to request more time to take care of this, and that way we could get everything in order, that way it's supposed to be.
Yeah, so is the city amenable to 6 days?
Sure. You
Yeah.
can do that. Yeah.
Okay. I think I'd be willing to provide, instead of 30, which is what was originally requested, 60 days to come into compliance, to give you some time to work with the architect.
I appreciate that.
Yeah. Okay, did you have anything else to tell me, sir?
I'm confused about the fine. Are you going to start getting fined now, or fined
No.
for the 60 days?
No, so after the 60 days.
Okay.
So what I'm doing here is determining whether a violation exists, and then providing you a time to comply. But if you go past the 60 days, then the fine would begin.
Okay. Also having now a confusion about here, because when they sent this paperwork, they gave me like A, B, C, D violation. So do I have to take care of the violation B and
What we're doing.
C, is it?
Yes,
B and C?
we're talking about B and C only.
Only. Okay.
Only.
So the rest is not addressed right now, right? You have to make sure I'm
Correct.
doing the right things.
Correct.
Yes.
Okay, so I need to get someone to deal with this, right?
Yeah, we'll stay in contact if you have any questions.
Okay.
You have my number.
I'll talk to you about this later, because I really don't understand anything about nothing here.
And Mr. Motavo, and I think all that stuff that you've done, it could be all combined in one permit, as long all the work, all the scope of work is put in that permit.
I was told I was supposed to go to the health department also.
That might be one of the requirements because
the
you're
toilet,
changing.
But that was not addressed on here. I'm not sure now if I do have to do that or not.
Yeah.
Because they said they need to make it like evaluation. Is the toilet, is the septic tank that I got is enough for the other addition. So, but it's not addressed in this, it's not being addressed here right now. Do I still have to do that is my question now.
The officer can provide you the phone number for the permit department so you can ask them again.
So okay, we talk. Okay, that's fine then. I'll have
All right.
nothing else to say.
Okay, I'm going to go ahead and make my ruling. So I find respondent in this case in violation of the city code as charged as to violations B and C, and that respondent correct the violation before 4:00 p.m. on, I'm going to say, December 23rd of 2024, which is actually 61 days. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day that each violation continues past the aforestated date. So it would be $100 total per day. And to the extent that you don't come into compliance in a timely fashion. Respondent is further ordered to contact the code compliance officer to verify compliance with this order. I'm finding the notices were properly given in this case, and I'm admitting the case file and the PowerPoint as exhibits. Thank you.
Appreciate it. Thank you, Aaron.
Thank you.
Do I I have to leave?
Is this the dangerous dog? No, okay. Yeah. Right, okay. All right, this is DEL 24-083, A, B, and C, a Massey case for 631 Cloudcroft Drive. Go ahead.
Hi. B was withdrawn, so this is just going to be for A and C.
Oh, only for A?
A and C.
Oh, A and C, yes. Okay, go ahead.
Hi, my name is Janice Palasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be Massey case number DEL 24-083 A and C. The City of Deltona versus Dwight Daniel. The property address is 631 Cloudcroft Drive. The parcel ID number is 813-042-130-190. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on August 28, 2024, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $50 a day, $25 per violation, since September 27, 2024. As of today, the property has accrued a total fine of $1,350 for both violations. The city is requesting that the fines continue at $50 per day, $25 per violation.
Did you say it was 1,350?
$1,350 total.
1,350?
Yes.
Thank you. Okay. And so these are the pictures from today, so we still have the deck in disrepair as well as the shed,
Yes.
correct?
Yes.
Okay. Is the property owner here?
No.
Oh. They're not here?
No,
Sure?
Your Honor, no.
Okay. I don't know why we took this case first then.
She's on call. And Lisa moving up, she's on call.
Oh, okay. All right. Gotcha. All right, give me 1 second. Okay. I find that respondent in this case failed to correct the violations A and C by the time specified in Special Magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance, and an affidavit of compliance has been filed by the Code Compliance Officer. Respondent shall notify the Code Compliance Officer to verify compliance. And I'm admitting the case file and the PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Thank you.
Yeah, but I think that's the witness, is that the only one? Dana. I can see the date.
Okay.
But then, yeah, just go to it.
All right. This is DEL 24-101, 1631 Hanover Avenue.
Hi, my name is Jeff Scott. I'm employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 24101, the City of Deltona versus Miranda Homes LLC. The property address is 1631 Hanover Avenue, Deltona, Florida 32725. Parcel ID number is 81301608030. This is a violation of City of Deltona Ordinance Section 9827, which states that it should be unlawful for any person to cut, move, remove, or destroy through damaging or to authorize the same of any tree as defined herein without obtaining a tree removal development permit in accordance with the provisions of this article. Corrective action for said violation is to pay restitution to the tree mitigation fund to be determined by the city, or planting of trees to replace ones that were removed, or reapply for the SFR permit. Statutory requirement for notification of this hearing have been met by the notice of hearing. Notice of code violation was sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was given to me from a previous officer in February of 2024 for lot clearing without a permit. This property originally had a SFR permit that was expired. Since this case has been active, the owner submitted a new SFR permit reflecting a different address, which is different from the previous permit. Myself and code manager have been in communication with the property owner, and they are aware that the additional documentation is needed to have the permit issued. Property owner was also made aware of this hearing. As of today, the permit has not been issued. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day. And the representative for Miranda Homes is here.
Okay. I have some questions, but I'll hold them until after you go. So can you state your name and address for the record, please?
Yeah, you want a business address or home address?
Business
Okay.
address.
Carmen Tarantino, Vice President of Construction, Miranda Homes, 3999 West State Road, 46, Sanford, Florida.
Okay. What would you like to tell me about the case?
The lot was initially cleared under, we had a permit at the time. We basically, there's a lot of things with the lot conditions, as I'm sure the officer can relay. We decided to not move forward with the initial plans, revised, applied for new permit back in April, went under review. We had an extensive list of comments to basically try and comply with. We don't have an in-house engineer or survey company, so that's done through third parties, so it took a little bit longer than normal for us to get some of the comments reviewed. We have since had them reviewed and submitted the comments, and we're just in the process of waiting to see if we have any more comments or any more information that we need to get the permit to keep moving forward. You know, it's our intention to comply with everything and make sure we're doing the right thing.
Okay. So for the city, well, I guess I know that tree removal permits are supposed to be submitted in conjunction with a development permit application, but I would assume that they are not normally, the tree removal is not approved until the application is approved, correct?
Correct.
Okay, and so the land clearing was done.
It was done with the old permit, which was active but then expired. So
Right.
then,
But just, I guess what I'm saying is, even under the old permit, it may have been active, but it wasn't approved, correct?
No,
Or was
it was
approved?
issued. It was
Yes.
issued.
It was
But-
issued and approved.
So
But it
Like
expired.
for example, I don't know what permit it's called, like a site plan or final engineering approval, it was given by the city, and then they conducted the land clearing?
Yes, we had a building permit for the lot.
Which is the tree removal part of it.
Okay.
So
So I'm failing to understand how there would be a violation if it was
The
done.
permit itself had expired altogether, and there was nothing done, just the lot cleared.
What expired? The site plan
The original
approval?
permit, the original permit that was issued expired, and the only thing was done there is the lot was cleared.
But
So
the lot was
once it
cleared while
expires,
the
that
permit was active?
The permit was no longer valid once it expired.
So, Your Honor, the lot was cleared under the permit at the time, which was valid.
Okay.
We didn't move, we started developing the site, and based on lot conditions, we decided that another house type would be a better fit on that lot. So we designed that, and the original permit, we let expire, and we applied for a new permit. And that permit's currently
Right.
under review.
But, I mean, again, the land clearing occurred while your site plan approval was
Yes, ma'am.
was valid and current.
Yes, ma'am.
Okay. I don't understand how this would be considered a violation then. If there was a permit to allow for the land clearing, the project may have been abandoned afterwards, but the actual land clearing occurred while there was a valid permit. Is there, am I missing anything?
Unfortunately, I didn't get to review this with the building official. I'm just thinking, because the tree permit was with the application for the single-family residence. Once that expired, and that tree permit also expired, everything with that application expired. So there is no active tree permit, and never got approved. It did get approved for the process, but never got completed.
Yeah.
That's why we are here as, because we presented because of expired permit. Now, it is in the works. We just haven't got it. The last we submitted, I think it was in July.
He mentioned that the documents were submitted a couple days ago, so.
We just didn't want this to stall and just, have a vacant lot here without an expired permit and no active permit on file.
Yeah. Well, the violation is for removal of a tree without a permit, and they had a permit. So I'm gonna dismiss this case. I encourage you and hope that you continue with the process of
Yes, ma'am.
obtaining your site plan approval. But I don't believe this to be a violation of the city code as it's been laid out here.
Thank you.
So I'm going to dismiss that case. Thank you.
All right, thank you. All right.
These guys are showing up, as witnesses or whatever for this matter, too.
Okay.
So, everybody's here.
Well, let's do the next one. Let's do the next one. Give him a minute. Okay, the next case is Fire 24-0059, 101 Howland Boulevard, Unit B.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire 059, 2024. The City of Deltona versus Walmart Stores East LP. The property address is 101 Howland Boulevard, Deltona 32738. Parcel is 920-604-000010. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4. Fire Codes 42-186, which applies, which adopts the most recent edition of the Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, Chapter 1.7.12.10, No construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. The violation of NFPA 113.3.3.1 mentioned on the notice of violation has been corrected prior to this hearing.
I'm sorry, which one was corrected?
13.3.3.1.
Okay, so we're only talking about 1.7.12.10.
Yes, ma'am.
Thank you. Go ahead.
Corrective action for said violation is to obtain a demolition permit for the interior renovation of Unit B and associated plumbing and electrical work. Statutory requirements for this notification is the hearing have been met by the notice of hearing and notice of code violations sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 29, 2024, I conducted a fire safety inspection at this address where I observed the above-mentioned violations. The property owner was notified in writing of the violations and given a time frame to correct said violations. Subsequent re-inspections on 5/24/2024, 7/3/2024, and 7/30/2024 found no progress on the violations. To date, the missing escutcheon rings have been installed and have come into compliance for NFPA 113.3.3.1. As for NFPA 1, Chapter 1.7.12.10, a permit for this demo has not been applied for. The city would like to request 90 days for the property to come into compliance with the remainder of the violations, or a fine of $50 per violation per day, for a total of daily fines of $50 per day, until the violation has been brought into compliance and the property owner notifies the city of compliance.
Okay, thank you. Can you, so what am I looking at the unit that was renovated, or can you explain the picture?
Yes, this is what the unit looks like now. Before it was a Dairy Queen.
Okay.
So all the walls were taken out, the plumbing, the electrical, and it was just left as a shell.
Okay, and it's now just a part of, is that part of the Walmart store?
Yeah, the Walmart's out front, and then they have individual suites like an eyeglass store, all different Subways and all that. So this would what we call Unit B.
Okay, so it's like one of the suites?
Yes.
Okay. Okay, sir, can you state your name and address for the record?
Yes, Brian Ankeny on behalf of the respondent, representing the address of 101 Howland Boulevard, Unit B, Deltona, Florida. If I may, Your Honor?
Yes.
Yeah, it's just as Inspector Nadeau stated, this was a unit that is, Walmart Stores East LP is the owner and lessor. Dairy Queen was the lessee, and after determining during the original fire inspections that occurred that there had been demolition, we were informed of it at that time as well. We attempted to reach out to Dairy Queen. We were working under the auspices at the time that as the lesser owner, but not the actual person who conducted any of the demolition, that it was not ours to permit. We've been told originally that we were not able to submit those permits after the fact. We did attempt to investigate. We ran down all of our contacts. Of course, it's now being 6 years later. It was hard for us to find anybody who had knowledge of that demolition. We determined that it did occur during that time frame. We were not able to find the general contractor who actually performed the demolition. We then, working with Ms. Nadeau as well as the city building official, Mr. Chad Tate, were able to perform a comparison with the original plans versus the current state of the store. We now have actually drawn up, we've hired our own contractors, we've drawn up the revised plans. They've gone through a few steps of revisions. Mr. Tate has been very helpful throughout this process. And we most recently, yesterday, sent him the finalized plans. We have not yet submitted for the permit yet because we wanted to make sure that everything was correct before. For example, the last issue that remained to be fixed was updating certain codes within it to the current standards. Mr. Tate has performed a cursory review. I actually spoke with him earlier today. He believes everything looks positive. Not to say that we're done yet, but now we're ready to finally submit for the actual permit. We plan to submit very shortly, soon, at which point he'll then complete a more thorough review of the plans, and then we'll actually go out to the site. There was some concerns because the current site is an iFix and repair, which is, as you see, is a white box with some tables, versus previously it had plumbing and electrical. So we're going to confirm that nothing was covered up, that everything's been capped as necessary, but as it stands right now, everything does look positive, and I believe the 90-day request is something that we can meet.
Okay. All right. Anything else? All right. Thank you. Okay. So I am going to find that respondent in this case is in violation of the city code as charged with respect to NFPA 1, Chapter 1.7.12.10 only, and that respondent correct the violation before 4:00 p.m. on this would be 90 days, which is January 21st, 2025. In the event respondent does not comply with this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance officer to verify compliance with this order, and I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you, Your Honor.
Okay. Oh wait, there's two of them here. DEL 24-096, 1385, is it Comerwood Drive?
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL-24-096, the City of Deltona versus Dorian Zelaya. The property address is 1385 Comerwood Drive, Deltona, Florida 32738. The parcel ID number is 813-038-110160. This is a violation of City of Deltona Ordinance, Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in good repair and sound structural condition. Corrective action for said violation is to repair or remove the fence, The statutory requirements for this for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed in the day they were taken. On September 3rd, 2024, a fence was observed in disrepair on the property. A door hanger was left at the residence. As of today, the property is still in violation. The city would like to request 30 days for the property to come into compliance or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay, thank you. And this is a picture from today.
I have another one from today.
Okay.
Go to the next photo, please.
Okay, there you go. You can see the panel still falling down. Is the property owner here?
No, ma'am.
Okay. All right. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on November 22nd, 2024. In the event respondent does not comply by this date, a fine in the amount of, I'm sorry, did you recommend 50 or 25? 25. $25 per day will be imposed for each day the violation continues past the aforestated date. A respondent is further ordered to contact the code compliance officer to verify compliance with this order. I'm admitting the case file and the PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Okay, the next case is DEL 24-098, 1587 Brady Drive.
Good evening. My name is Bashir Turksi. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 24098, City of Deltona versus Susco John TR Trust, John Susco Removable Living Trust. The property address is 1587 Brady Drive, Deltona, Florida 32725. Parcel ID number is 813055030020. This is a violation of the City of Deltona, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, remove, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the newly installed window. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida 32725. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office with the permit number when obtained. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This is a proactive case that was opened on March 31st, 2024. While addressing a separate violation at this property, I observed a recently installed window without a permit on file. I spoke with the tenant and advised her of the violation and the necessary corrective actions. A notice of violation was posted on July 16th, giving the property owner until July 26th to comply. As of today, no permit is on file and the property remains in violation. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay, thank you. So this picture is showing me the previous window?
That is the original window, yes.
Is that a window? Or what is it just like a decorative?
No, I think that's like a curtain behind the glass.
Oh, it's a curtain,
Yeah.
okay. And then and
that is a newly installed.
I see.
Yeah.
All right. My only question would be for a 30-day time frame on the windows, does that normally require any kind of engineering or anything? That may be, I'm only concerned about the amount of time.
It all depends on the modifications to the wall. If they had to, make the window maybe bigger or something, it might necessitate more time.
Yeah.
But the city is willing to work with them on time as long as it's reasonable.
Right.
Yeah.
So I'm thinking 60 days would be more reasonable in this case.
That is fine. Yeah.
Okay. Yeah. Is the property owner here?
No,
No.
I don't think they're here.
Okay. I'm going to go ahead and find that respondent in this case is in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on December 23rd, which is actually 61 days. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance officer to verify compliance with this order, and I'm admitting the case file and PowerPoint as exhibits and find the notices properly given in this case. Thank you.
Thank you.
Okay, the next case is Fire 24-0058, 152 Hummingbird Street.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-058-2024. The City of Deltona versus EOE LLC TR-TR-Trust. The property address is 152 Hummingbird Street, Deltona, Florida 32725. Parcel is 803-605-070100. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains Florida-specific version of NFPA 11.1.2. All new electrical wiring, fixtures, appliances, and equipment shall be installed in accordance with NFPA 70. And Chapter 1013.2.1, cut or uncut weeds, grass, vines, and other vegetation shall be removed when determined by the AHJ to be a fire hazard. Corrective action for said violation is to repair damaged electrical panel and replace the missing interior cover for Unit 1's electrical panel, replace the unapproved exterior cover and provide an approved interior cover box for Unit 3's electrical panel, removing the overgrowing vegetation on top of and above the electrical panels. Statutory requirements. The statutory, for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the property listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 29, 2024, I conducted a fire safety inspection at this address where I observed the above-mentioned violations. The property owner was notified in writing of the violations and given a time frame to correct said violations. Subsequent re-inspections on 5/24/2024, 7/3/2024, and 7/30/2024 found no progress on the violations. Upon today's site visit, no progress was made on the violations. The city would like to request 30 days for the property to come into compliance with the remainder of the violations, or a fine of $50 per violation per day, for a total daily fine of, should be 100, right? There's 2 violations, so it should be 100 per day, until the violation has been brought into compliance and the property owner notifies the city of compliance.
So $50 each is what you were recommending. Okay, and can you just briefly show me, so for Unit 1, you're saying there's a damaged electrical panel cover? Is that what I'm looking at?
I believe that's Unit 1. They're both next to each other, but the cover was actually missing, so a fabricated cover was made.
I see.
To cover. And then there's another picture. Sorry. And inside of this one, the picture will show Okay, that's both boxes next to each other. Then there's a few pictures, there's like 6. And then the last box, which I believe is Unit 3, is actually falling, it's not secured anymore.
Okay.
And then inside of 3, the whole interior cover that protects the wiring is missing. And then back to the silver, the one that was fabricated, there's actually a piece that's missing inside that is leaving wires exposed.
Okay.
If we scroll, there are pictures of that in the slideshow.
So that's, whoops, go back, please, 1. Sorry. Okay. Keep going. So inside of the one that was fabricated, that's the open spot where it's exposed wires.
Okay.
And then keep going forward. And then, oops, go back 1. And that's the exposed wires in the last one for Unit 3.
Okay. So they're in both boxes?
Yes.
And then on the
vegetation,
is there a picture of that?
Yes. I don't know. Oh, there, okay. So this is new vegetation is encroaching the breaker boxes. And then if you go 1 more forward, that way. There you go. Then there's vines and stuff that are still up on top that have been not removed.
So is the violation related to the vines or is that a tree?
There's like an empty lot next to it, so those trees are encroaching.
Mm-hmm.
And then the vines, they're just still growing, so it's still a fire hazard if they were to catch fire with the electrical.
And I just want to be clear in terms of compliance. So if they were to remove the vines, is that sufficient, or are you asking them to also trim the tree?
Also trim the tree as well.
Trim back the tree? Okay.
Yeah.
The property owner is not here, correct? No. Okay. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before, yes, you said 30 days. Maybe before I make my ruling. So just my question on the 30 days, to find the appropriate cover, do you think that 30 days would be sufficient for that? I don't know how difficult it is to obtain a cover. That's my question.
And being the old units, the old boxes.
Is having problems finding a cover?
Yeah.
Okay, so maybe we'll go with 60.
Okay, 60 days.
Because if they can't find a cover, they may have to permit for a new panel.
Mm-hmm.
So it may take some time.
What I could do is do 60 days for the cover violations and 30 for the vegetation. Because obviously that seems to be, you're determining that's a fire hazard, so I'll do that. Okay, so starting again, I find respondent in this case in violation of the city code as charged, and that respondent to correct the violation of NFPA 111.1.2 within 60 days, or actually 61 days, which is December 23rd, 2024. And that respondent correct the violation of 10.13.2.1 in 30 days, which would be November 22nd. In the event respondent does not comply by the state, a fine in the amount of $50 per violation, so $100 total, will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance officer to verify compliance with this order. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you. It's the last one? Okay. So now I have the DEL 24-095, 974 Winbrook Drive, which is a dangerous dog case.
Good evening. My name is Larry Sparling. I'm employed by the City of Deltona as a Code Compliance and Animal Control Officer. This will be continuation of case number DEL 24-095, the City of Deltona versus Amanda Norville and Kevin Cowork Jr. The property address is 974 Winbrook Drive, Deltona, 32725. The parcel ID number is 813-012-010-090.
So,
excuse me.
before you continue, so in this case, I continued it to allow for additional witnesses. Do you have any additional witnesses to present?
No,
Okay.
they didn't show.
Okay, so I just want to be clear, I don't want to rehash all of the testimony that was given at the last hearing. Because I recall it well. So what I would say is I would just allow for the city and the dog owner, if you want to make basically like a closing statement, and then I'll make my ruling.
Okay, so my closing statement, to summarize, we would say that we have shown that Mr. Cowork's dogs have aggressively bitten, attacked, and inflicted severe injury on a human being when they attacked Ms. Hertzberg on June 17th. That satisfies Section 14.1 dangerous dog definition number 1. In the two attacks, they have more than once severely injured a domestic animal while off the owner's property. This meets Section 14.1 dangerous dog definition number 2. Both incidents being unprovoked, approached and attacked meet definition number 4. We would ask to find them as dangerous.
Okay, thank you. Is the dog owner present?
How you doing?
Good evening. Can you state your name and address for the record?
Kevin Cowork Jr., 974 Winbrook Drive.
Okay, thank you. So again, if you'd like to make any closing remarks to me, you can go ahead and do that.
We did bring some additional things in, but I don't know if we were going to do the closing arguments, but I brought the collars because I wanted to double back onto that. But we brought the collars with them saying that it was thick buckled. And
Can you speak up a little bit? It's hard to hear you.
I apologize. We do have additional items that we were going to submit, but if we're just doing the closing items, I guess or the closing arguments, I guess that's fine. But
Okay.
we brought the
What were
collars
you
in.
wanting to
We brought
present?
the collars in with her saying that they were thick buckled, the belt type of collars. We brought those in, and with her stating they were striped. And
Okay.
we were going to have a witness. I don't think she's able to make it. Her children were.
Yeah.
Somebody knocked one out.
I recall your testimony that the collars were striped.
Okay, so I guess in closing, like I said, I don't really feel that the first incident was a vicious attack or a violent attack. Outside of that, like you said, you know the testimony that I gave last time. My dogs are good dogs. I know every homeowner is going to say that, every pet owner is going to say that, but it would devastate our family if we had to go through this because I wouldn't be able to afford keeping them. We weren't in town, and we have numerous people that have seen the dogs. We have since seen the dogs. There was a doorbell reading that came up that said 2 pit bulls were at large, and they think that they were the ones that killed a cat, like days prior to that. So
You're saying they were other dogs?
yeah.
Yeah.
And we found a photo of them, and it looks into Luna, one of our dogs. And they had collected 2 dogs at that time. They only showed a picture of one. I've seen both of the dogs, and the other one looks just like Jem as well. I apologize. I don't like talking in front of people.
It's okay. Right. Does that conclude your remarks?
I guess it does, Madam Magistrate.
Okay.
Thank you.
All right. So I'm going to make my ruling. I'm going to find the dogs dangerous in this case. However, let me explain my reasoning. I'm not finding the dogs dangerous based on the second incident that occurred. I find that the testimony that was provided was not clear about the identity of the dogs that attacked during the second incident, and there wasn't a clear identification of those dogs. In addition, the dog owner did testify that he was not at home at the time, and his dogs were with him, as well as presenting other corroborating not testimony, but corroborating documents from neighbors stating that there were other dogs that look similar to his in the neighborhood. That being said, one of the ways that a dog can be, or dogs can be determined dangerous is that they can be determined dangerous when unprovoked they have chased or approached a person upon the streets, sidewalks, or any public grounds in a menacing fashion or apparent attitude of attack, provided that such actions are attested to in a sworn statement by one or more persons and dutifully investigated by appropriate authority. And well, actually, let me clarify this. I don't believe. Well, let me ask this question.
I'm sorry, go ahead.
Yeah, let me. The first incident, and I'm going to ask the city, and I'll ask you as well. Did that occur on public property with Minnie?
No, that was at 910 Windbrook in the front yard.
In the front yard. Okay.
Not on the dog owner's property.
Not on Minnie's, the owner of Minnie.
So that dog's owner, right? It was there.
Okay. All right. So I'm actually gonna change my ruling. So I'm going to find that the dogs were not dangerous.
Thank you so much.
Like I said, I don't believe there was enough evidence provided on the second incident. And then in addition, I don't find that there was severe injury to domestic animals, again, because the identity of the dogs were not clear. And then with respect to being chased or approached, that didn't occur on public property under the third prong of the test. So I am not going to find the dogs dangerous in this case. I hope that, the case is concerning to me. I hope that you...
If I may, the two dogs that we do see, we believe are in the Gaucho Cloverleaf area, and there is a development that they go into, and then they come out right behind where her house is, the back gate. That's where we usually see them, is right around her area, and I believe that they are dangerous. They've attacked cats.
Okay.
And
Well,
Verizon neighborhood, so. Like I said, we saw a door ring cam, and we know it's in that area, so me and my wife are actively looking for the dogs. If we are able to find them, we will let her know.
okay.
I bet they have striped collars.
What I'm saying is, I think you, as a dog owner, has basically said that you didn't really contest what occurred on the first incident. So please make sure that you are, keeping your dogs appropriately.
We have a kennel in the backyard, and we leash them when we have them back there.
Yes. All right, that's going to conclude the hearing on that matter.
Thanks again.
May I have a word?
No, ma'am. I've made my ruling. Thank you. All right. Do we have any other cases? Okay. Just for the record, Renee, I did sign the minutes from last time, and I do have the originals of the 2 lien reduction cases here for you. And I think if nothing else, we'll go ahead and adjourn. Thank you.